Добрий день, я вітаю всіх, хто приєднався.
Good morning. I want to thank everybody who joins us. My name is Oleta Manema, and it's my pleasure to welcome you at Ukraine Media Center. Today we have invited you for the presentation of findings about the systemic failures of the Interdepartmental Commission under Ukraine's Ministry for Development. We know that at the Ministry of the Development of Communities and Territories, there is a commission that deals with investigation of the facts of deprivation of the Ukrainian citizens of their freedom by Russian Federation. Today we are going to present the findings about the freedom deprivation, and right away I would like to share it with you that this study was prepared by the Association of Relatives of Political Prisoners of Kremlin NGO with the support of Ascolt and Deer Foundation, and is funded by the governments of Norway and Sweden. So let me introduce our speakers today.
Сьогодні з нами Ігор Kotelianets, голова об'єднання родичів.
Joining us in the studio is Ihor, head of the Association of Relatives of Political Prisoners of Kremlin. Also joining us is Kateryna Levchenko, chief lawyer of the Association of Relatives of Political Prisoners of Kremlin. Also joining us is Kostiantyn Davydenko, deputy head of the Civilians and Captivity NGO. Hennadii Azzeurov, survivor of Unlawful Detention. He's joining us online. Hopefully Mr. Hennadii can hear and see us, as well as Danylo Bulhakov, deputy head of the communications at the way of the Freeman NGO. Thank you for joining us. I would like to thank everybody joining us both online and offline. And Mr. Ihor, I would like to give the floor to you. Can you please tell us why such an expert perspective was taken? Just a little bit about the problems touched upon in this report. Well, good morning. Good morning. I want to thank everybody who joins us online and offline. Today we're presenting our work that has taken us about 4 months. That was a commission investigating the facts of deprivation of personal freedom. So why did we decide to undertake this activity? Because first of all, talking about the civilians who ended up in illegal detention, those who need the support by the state one way or another to get access to such aid, to such support, after being set free, or for their relatives who are fighting for their loved ones to be set free. They need to use the procedure approved by the state that contemplates that people need to submit an application for a specialized commission. It works at the Ministry of Communities and Territories Development to establish, so to say, the fact of illegal freedom deprivation. So we've analyzed the work of the commission within the last 7 months. Why 7 months? Because previously this commission was working under the Ministry of Reintegration, and for us, as an organization that was advocating and launching the work of the Commission at the Ministry of Veterans and Temporarily Occupied Territories, then since 2018, then we were advocating the adoption of the Law 2010 about social protection since 2020. So basically, we were involved in every stage of development of this system, and since the system started working, we continue exercising monitoring to identify whether it does work or not. Do the citizens of Ukraine really get the aid? Aren't they restricted when it comes to provision of such aid? And we try to look at the problems that we can solve. I personally was a member of the commission when it was working at different ministries, and I know how before the year 2022, and I know how difficult it is to work in such a commission, how difficult it is to evaluate the cases, how difficult it is to identify whether a person falls under the requirements of the law. Also, it's difficult to see systemic problems from the inside. They are better visible from outside. That's why we hope that such an view from outside, we called our presentation an audit in parentheses. That's what Alexei Ryabikin will deep us. Basically, in an interview, Mr. Ryabikin, Deputy Minister for Development of Territories and Communities, that's what he called our report in the interview. And in this study, we can see how the operation of the committee was organized under the new ministry, whether the new ministry changed the approaches, did they solve any problems. So basically, the results of their work can be visible based on the data about the people who are supposed to benefit from it. So basically, who are supposed to be receiving aid. Getting back to the statistics as of October, we've seen that within 7 months of their operation, the Ministry of Development held 11 meetings of the Commission. That's a lot. I can compare it with the way the Commission was working on other ministries. The requirement is to have meetings at least once per quarter, but given the fact that thousands of the civilians ended up in illegal captivity, that's quite a positive change that the Commission is now meeting more frequently. It means more people affected get their documents reviewed. Well, hopefully they will get the aid too, but still the fact that they have their documents reviewed is already a positive aspect. During our examination, we've analyzed the approaches of the Commission, their operation. We were analyzing what the members of the Commission were saying in the public space. We were checking the statistics, and we see that as of October, now the figure is bigger, but as of October, the Commission reviewed more than 4,000 applications. About 3,200 of those applications were agreed upon. There was a positive resolution taken in their regard, but still we have to understand the ministry didn't provide any specific data. Still we have to understand that absolute majority, 90-95% of the applications are the applications for the military. They always get a positive answer. They are also approved. And when we see such number 4,000, including 3,200 approved, which means that the people will be eligible for aid, that's already covering the civilians. We don't have the statistics of refusal, but comparing the numbers, we can assume that the number of refusal for the civilians maybe from 30 to 50%, a huge number. We see the confirmation of such dynamics in the operations of our support center, in our NGO. Like we have this center, and the people addressing us, they mostly ask us to put together a set of documents or something like this. So basically they require legal aid, and now we are going to discuss what to do with it. During our public examination, also in October, we had a roundtable organized that engaged 35 organizations. We checked the watch with other NGOs who were working with the similar problems, and that experience was taken into account in our public examination. Also, we've checked the court practice. We were examining the statistics, and the people who were not able to identify the fact, they were considering that the resolution of the committee was illegal. They brought it to the court, and then we'll discuss whose side the court is taking. Well, when it comes to the problems, we do the annual monitoring of the Commission operation annually. That's our normal work, and we come across issues, when people who are being set free from illegal captivity, when we survey them, when we analyze the data to confirm that a civilian was really staying in illegal captivities, we help a person to put together the paperwork, and in case the person is being refused, for us it poses another challenge. We don't always understand why they were refused, because the ministry doesn't provide any clear feedback. Well, it's not unclear only subjectively, not unclear to me. It doesn't comply with the requirements of the law of Ukraine on administrative procedures. It doesn't have comprehensive motivation. I'm not going to stop at that. The colleagues will cover it. So the applicants, they don't know what to do with their refusal and how to fix things, how to prove the fact of their illegal captivity and to get access to the state aid. Talking about excessive requirements to the applicants, we mean the absence or weak accent on human-centric and victim-centric approach of the members of the Commission when they evaluate such cases. So based on that monitoring, on our monitoring, we were able to see that all of the burden of proof that a person was in illegal captivity is put on the applicant, in view of the fact that the law regulating the activity of Commission was adopted before the full-scale invasion. It described the reality that existed before the full-scale invasion. It was supposed to be helping people in occupation, mostly in Crimea and certain districts of Donetsk and Luhansk regions. Well, it was applicable for the people who were expressing their pro-Ukrainian position, and the occupiers imprisoned them for that, and they didn't even try to conceal it. That was visible from the materials of the case. After the beginning of the full-scale invasion, the situation has changed, and the occupiers in newly occupied territories, they detain people who were not previously involved in any civil activities, and to prove that they had any Ukrainian, pro-Ukrainian views, it's just impossible. That there are no certificate issued about that. The occupiers just, without pressing charges, they just artificially restrict access to the wall. So basically putting people in captivity. A lot of people experienced tortures. A lot of people experienced CRSV, and they are the people whom the occupier captured based on unknown reason. And in the same way, when people get released after, say, 6 months, they don't know why they were released. Nobody explains it to them. So in the conditions of this new reality, when, first of all, some continuous activity is being observed, when people were just living, political activity, when people were living their lives paying taxes and then they get captured, we would like to put this responsibility on the state. The state was not able to protect a person. It was not a person who attracted this situation. It was the state who failed. And if a person survives illegal detention, tortures, and stuff like that, the state has a second chance to exercise their monopoly for security, to provide the security as social protection, legal protection. So we're saying that putting all responsibilities on the applicant, those who lost all their property, lost their land was occupied, they were kept in illegal detention, the people were able to make it out of there, they came to Ukraine, they expect that they would be helped in some way, at least supported, at least they have something to eat, where to sleep, and they are being faced with the list of non-human centric details. You have to provide some details that would prove everything you say is true. I mean, this discussion is way more broad than the operation of the Commission. It should be transferred to the domain of legislation amendment. But when it comes to something that can be changed in the approaches of the committee, is like what should be changed is not to mistrust the people, not to make them try to prove something. It's like the people are being released and they are being forced to pay taxes, and they say to the state, like, okay, prove that you did everything that you could, like to the best of your capabilities, to protect our property, protect our jobs, so we could pay taxes to you. But again, the Commission should have the requirements to the Commission itself. A lot of information about the fact of detention, about any information emerging online or in the law enforcement. I mean, that's the data that the Commission can gather themselves. And as we were undertaking this examination of ours, we've seen that the Commission doesn't exercise all of its capabilities, and they don't help the victims to prove the fact of the imprisonment. So this commission comprises the people who are not always involved with this topic, the regular people who work in the ministries, NGOs, they live their regular lives, and it cannot be the work of their lives. Those people didn't undergo any training on how to do it, so based on the theory of complex systems management, when you don't know, when you cannot be a specialist, as an expert in your role, you have to address the experts. And it's also in our recommendations, the Commission should not just refuse the cases that don't contain sufficient amount of objective data on, like, in a conveyor-like way, but probably try to find out that information by themselves, and also to address the experts in international humanitarian law, the lawyers, documenters, like a branch organizations that can, upon the request of the Commission, analyze a person. If you take it apart, whether what a person tells, whether it coincides with what was going on in that territory in that moment in history, whether there are witnesses, whether there are other survivors who remember that that person was in illegal captivity. So this contextual analysis is incredibly important. In any case, a person who made it out of illegal occupation, they require help and support, and by default there should be trust. Let me finish here so that my colleagues also have time to say what they wanted. Also, let me remind you that also there is a printed copy of the study. We won't be able to cover all of the aspects of the study in the studio today, but so please get yourself familiarized with the study. Thank you, Ms. Kateryna. Let's cover other aspects. Good morning, everyone. In order not to repeat what was already said within the years of our activity, starting from the first public examination and then proceeding to the monitoring surveys, we've noticed that the progress in the work of the committee does exist. Our advice was heard. Our recommendations were heard. We think that it's good that the form of the application was changed, that significantly facilitated understanding of the applicants about what the Commission wants to see in the application, what they need to take this or that make this or that resolution. But the study was not only about the operation of the committee, but also about the complex activity of the work of the ministry when it comes to the rights of the applicants. So talking about non-transparent work of the committee, those are the questions not to the Commission but rather to the ministry, because as Ihor has mentioned, all of the operations should be guided by the law on administrative procedure, which contemplates that the resolution of the committee should be put together in certain form. And if such resolution contains a refusal, it should be argumented and motivated. So when the refusal is, when the applicant is being refused, they are being refused by the letter from the ministry, and the ministry just provides some general wordings that there was your application was reviewed, but it didn't gather sufficient number of votes. So how it can help the applicant? It doesn't help during the repeated application or application to a court. We think that the resolution about refusal should clearly outline what information was missing about the place of captivity or the term of captivity, the motives. So after the refusal, the applicants should get a clearer understanding whether they should get additional data and to resubmit their application, or should they dispute it in court, or they should realize that they were mistaken and they don't have legal grounds to apply to the Commission. So basically such a position about the motivated refusal is corroborated by significant court practice, which is legal. So with its resolution, the court obliges the Commission to review the application in a repeated way and to provide a motivated response. In such a way, it doesn't solve a problem neither for the applicant nor for the Commission. They review it again, but they have to provide additional motivation. Why doing it? Why creating those additional circles of help for the applicant and repeated work for the Commission if they can do it right away? Or as Ihor mentioned, to get those details by repeated application. It's contemplated by the law that there is a term for response from any government agency, but for what we know, the Commission doesn't use that right of requiring more additional data from the state agencies on top of the rights that Ihor described in detail, that the law on administrative procedure contemplates different procedures of facts corroboration, such as involvement of experts, requesting additional evidences, but there is also the way that is not used by the Commission, that a person can be heard to. Within the years of existence of the Commission, only one person was heard to, and we know that based on their applications, it was not only the one person who wanted to be heard. The people wanted to explain their applications. They wanted to add some data that they cannot put in writing, or to explain some contradictions existing in the documents. For example, when it comes to the dates of detention, different government agencies, they may have different dates in their documents. We think that it's a violation of the processual right of a person that should be exercised upon the desire of a person, upon the request of a person. So now let's proceed to another issue, the structure of the commissions. As Ihor mentioned, the structure of the commission has been remaining unchanged within years, but we need to explain that we don't have any claims to the existing structure of the commission. The way the law contemplates it, the commission is made from the representatives of government agencies and representatives of non-government organizations, 5 different non-government organizations, and the structure of the commission is approved by the resolution of the ministry it submits to. So when it comes to representatives of the government agencies, everything is okay, but when it comes to representatives of non-government organizations, the structure has been remaining unchanged for years. But again, given the realities, given the fact that the structure was approved before the full-scale invasion and it's been transferred from one ministry to another, it doesn't take into account the fact that since the beginning of the full-scale invasion, a lot of real powerful civil organizations were established who would like to take part in the activities of the commission. They have intense base of beneficiaries. They have a lot of information that could be useful for the commission. So basically, now the number of civil organizations involved with this topic has grown times multifold, and we deem necessary to update the structure of the commission so that we can avoid the situations when the representatives of non-government organizations, they coalesce with this commission, they coalesce with the government agencies. We've suggested the procedure for the contest. There should be transparent conditions, and the members of the commission must be changing on a regular basis. Well, another problem of the ministry is when the people establish the fact of deprivation of personal freedom, they are entitled to annual disbursement. Then they submit the application to the ministry to get that annual disbursement. Without any response, people can submit more and more applications to the ministry, and they can get a response. Like the law doesn't stipulate the term of such annual disbursement, and sometimes it can take years. So the ministry is not even guided by the fact that the disbursement is called annual. Based on the analysis of the court practice, there is a standard that if the law doesn't set forth the term of payment, such disbursement should be made 30 days after the application was received. So the fact that the date of the disbursement is not set forth in the law doesn't exempt the ministry of such disbursement. Also, there is a Levchenko stipend issue, but the number of those who receive this stipend is not so numerous, so this problem doesn't have such a scale as with the annual financial support by the ministry. Also, there's another issue when a person puts together a power of attorney to entitle another person for such to receive such a disbursement. And in such cases, the ministry refuses them, and people don't get their annual payments. Well, I can see the recommendations slide. Who is ready to comment? Well, let me get back to it. The expert recommendations contained the suggestion to solve that issue with a negative response of the Commission to standardize these decisions so it complies with the law on administrative procedure, so it should be motivated and argumented. It should contain necessary details as well as information about disputing. It should guarantee a right to be heard too. If it requires any amendments to the procedures of the Commission operation, such amendments should be made when additional documents are requested, when people should be heard, when additional examinations need to be taken, and what I've already mentioned, to implement the transparent contest for the members of the committee. Thank you. Thank you very much, Kateryna. And I would like to give the floor to Mr. Hennadii. Mr. Hennadii, hopefully you can hear and see us and you are ready to take part in our conversation. Good morning, everyone. I can see and hear you. Thank you very much for your invitation. That's really an important issue that requires everything that Mr. Ihor has mentioned, as well as the previous speaker. The story of a cooperation with the committee, cooperation between the civilians who were through all those circles of hell themselves, and as they come back to the territory under Ukrainian control, they are facing more problems. You know, it's absolutely demotivating. I can tell you my story of cooperation with the Commission. It's quite romantic and interesting. All my life I've been working in Mariupol. More than 30 years I was serving with the police. I was a former combatant. I ended up in captivity. It happened so that before the full-scale invasion I retired, and in the beginning of the full-scale invasion I was already retired. So de jure I ended up in captivity as a civilian, and as I was released, as Mr. Ihor was mentioned, I was released without any explanation of reasons. And by the way, I was staying in the infamous Olenivka. So without explanation of the reasons, I was released, and I started cooperating with the Commission. It was almost the end of the year 22, beginning of the year 23. And 3+ years, I was trying to do something by myself. I submitted 4 applications. I got 3 refusals within these 3 years. But again, as a former combatant, what I was demotivated with is when you're through all of that, when you were taking part, when you were involved, you are being told like, sorry, but you didn't provide sufficient proof to be recognized as an affected person. Like, in my own experience, I can tell you, takes you just 1 week to process this information, to analyze like what exactly was that you've done wrong. Then also when you apply, when you submit your application, there is no clear list of the documents for a civilian. What am I supposed to submit? Which documents? In which way? And as it was also mentioned, when the form of the application was changed, it really facilitated the process, and it provided better understanding of what needs to be done, like which information the ministry wants to see. But when you provide such information in a free form, that's not quite right. First of all, the way the law is construed is like proof that you've done something for the state. What am I supposed to prove when I was taking part in combat operations, when I came back to the territory under Ukrainian control, making my way all across Europe? I didn't stay elsewhere. I came here. I'm here in the territory of Ukraine. I'm trying to do my thing. I support the guys who were defending Mariupol to find their ways in their lives, to do something. Again, that's a demotivating factor. And yet another issue, the structure of the committee. Of the commission. Twice I had such cases when I get a response after I gather the paperwork. I was a policeman myself. I know that committee is made up also of the representatives of the National Committee, and I was suggested provide the numbers of the entries in the pre-court investigation register and how those criminal proceedings were evolving. As a civilian, I don't have access to the databases, and knowing the fact that there are representatives of law enforcement in the commission who can do it, it would take 3 minutes of their working time to do it. And for me as a civilian, it takes 2 months to gather all that information, all that paperwork. That's not right. That's not good. Mr. Hennadii, your work has taken you 3 years. Yes, right. And within that period, did you try to take advantage of your right to be heard? Well, yes, it was, but I was getting refused. No, not refused, but it was just ignored, so to say. Last time when I submitted my last application, that was back in the beginning of the year 2025, when I, without any response from the commission, when I addressed the Association of Relatives of Political Prisoners of Kremlin, well, that's when some movements started. It's the commission, but most likely not the commission. The commission provided no response whatsoever. That was the ministry responded for the commission. We had such an experience of communication with the ministry, and something happened, and they finally recognized me. Mr. Hennadii, thank you very much for sharing your experience. Sometimes it's very difficult to hear. Sometimes it seems like we live in different dimensions, because you hear about the problems of the people who really need help. Well, Kostiantyn, I would like to give the floor to you. Can you please share your experience? I know that you also have experience of work, so to say, with the Commission. So what was your experience? Good morning. Well, my experience with the Commission was not related to the fact that I had to prove something, because in my case, the Commission has taken the resolution, well, when I was in captivity. Well, it also took long, but anyway, when I was exchanged, it was not an issue anymore, but there were other challenges when it comes to power of attorney, because I couldn't submit the documents personally because I was in captivity. And they didn't want to let me go just for 1 day so I could sign some paperwork. And my parents were also in occupation. They couldn't do it. That's why the civil activists were doing it, specifically Mr. Ihor. And that procedure was taken very long because of that, because of the complexity of the document submission. And then when we were already exchanged, I've seen that those exchanged when they submit the documents, because we were spending time together in the hospital discussing it, and then I got involved in civil activism, and now we work with those people. We hear out to their problems, trying to help them. And I was coming across the situations when people were exchanged, like that person was exchanged in the border. The Russians brought them to the border. Our guys met them. They wrapped them in the flags, brought them to the hospital, and they tell you, you were not in captivity. So how come I ended on the border? How come the Russians gave me to Ukrainians? I mean, those discrepancies, like discrepancies even with the common sense. You were just exchanged, but you are not recognized as a prisoner of war. That's just illogical, right? Ms. Vereshchuk was touching upon this issue back in the hospital. And after it was mentioned, when Ms. Irina mentioned it should be solved because it's just absolutely illogical, some of those people were confirmed as former prisoners of war. But hence the question, why did they have to wait until someone personally gave some command to make it happen? So it could have been done from the very beginning, right? So why wasn't it done? Not only that I'm talking about, but also other issues that my colleagues have already covered. So again, it's not a problem of personalities. They are part of the Commission. They act in accordance with the law, and according to the law, they are supposed to act just like that. So the problem is about imperfection of the law, because, again, a person comes back from captivity. They may not be very well oriented with what's going on to them now. They might have spent some time there in captivity, maybe even without tortures, but others within a week could experience something that you would be horrified to hear. And some may have spent 9 years there or 7 years, and people may come back desocialized, lost, frustrated, definitely with mental health issues. And after they are being refused on initial stages, definitely they will be shocked. They won't start knocking at all doors. They will just ask, how come? It demonstrates the attitude of the state to these people. That's why the issue is not that we sit here and want to say that the Commission should not refuse anyone because we are concerned about that people. No, it's about the state taking care about the citizens. This is what the state exists for. We want to be a democratic country, and we want to base our activities on democratic principles. There's a state for a citizen, not a citizen for a state. And if a state exists for the citizens, they should gather all of the evidences, because they have way more possibilities to gather those evidences, request them from law enforcement agencies, to conduct an OSINT investigation, because frequently the occupiers post the videos of how they steal, how they abduct people, how they detain people. For example, there were 2 or 3 videos on YouTube about my abduction. What we definitely don't have to do, what the Commission doesn't have to do, the Commission doesn't have to use the Russian documents in their operation. And quite frequently we hear a refusal. They say your captivity is not confirmed because there are no paperwork provided by those who were detaining you. For example, there was a guy in a cell with me. He was detained in Saratov. He came there to look for his brother. Well, they had some family issues back in 2016. Right in the airport, he got seized. He was a big, like a real big guy. He was living in Moscow, and then from Moscow he came to Saratov, and they were trying to incriminate that he was a fighter of the private sector, the right sector, like the Yarosh business card and stuff like that. They were making him recognize his guilt for a week. Well, he didn't, and then they wrote that he was carrying drugs, and he was sentenced to 7 years for drugs. But in fact, he was spending that time in prison just because they didn't want to let him go. In my personal case, when I was detained, the first resolution about this detention, the copy of the resolution that was sent by Russia to our consular department. Back then, the consular department was working. So in that copy, it was mentioned that I was detained not for espionage, what I was standing trial for, but for drugs, so that the consul doesn't pay attention to me, doesn't visit me at the colony. So we have to understand that we cannot, the Commission cannot rely upon the documents issued by Russia. We can only trust one agency, Ukrainian investigation, because the Commission is not an investigative authority. They don't conduct investigations by themselves. They cannot study things by themselves. Only this work in coordination with the law enforcement can prove that, can either prove or debunk in case someone provides any untrue evidences. But still, it shouldn't be done by a person, but rather by a state. Thank you. Thank you very much. Danylo, please let me give the floor to you. Also, what I would like to add, sometimes we keep omitting it when it comes to the people who are being exchanged or being returned beyond exchanges. People who are being exchanged, they idealize our state because they understand that your only chance for survival to be saved is Ukraine. And for years you stay there and you keep thinking that Ukraine is going to take care of you. And there's a whole different situation when a person comes back from exchange and they find out they were never in captivity, or they come back by themselves after years, and the state just doesn't care whether they exist or not. They get refused by Commission, for example. And you know, those people, they miss the whole stage of their lives. For example, in the hospital where I met Kostiantyn when he came back, you know, the family doctors, we know what family doctors are. People who spent 8 years in captivity, they don't know what it is. They didn't witness that reform, and now they are being presented this application form they don't understand at all, and no one communicates. There is no with them. There is no case manager from a commission. People have to look for them themselves. Such organizations as civil sector or association of relatives of political prisoners of Kremlin, I mean, they help such people, but what happens to such people when they get the first refusal? Very frequently, people who leave Russia and they come back to Ukraine, they just don't want to come back to Ukraine. I was released in the brink of the year 23-24. You know, we were released because the Russia didn't decide what to do about us. And out of 300 of us, only 3 people came back to Ukraine. The rest are afraid to come back to Ukraine. They understand that they won't be able to live for Europe again. They can be mobilized. They are in very bad condition. No one can guarantee that the Commission will recognize their captivity. However, many have evidences. I was staying with those people, but the Commission still refuses. In one case, a wife of a person who was sitting in the same cell with me, they wrote like, maybe he was really imprisoned for the drugs. Like his wife was imprisoned for espionage, and the guy was imprisoned for the drugs. Well, those are the situations that instill mistrust in the state. The state has to grow socially, but instead of that, we're getting a system that doesn't know how to operate, that contains the people that don't know how to work within that system. Probably that legislation was created for some small number of people who were working together with the security and defense forces, but the situation has changed dramatically. People are getting imprisoned in such numbers that didn't happen before, and those people don't fall under this law in no way. And there is no organization within the ministry that would be made of the people who were previously imprisoned. I may be mistaken. I apologize. What was the organization that was established after year 2022? Well, I would like to ask to pass the microphone to the floor. Well, yeah, let's finish and then proceed to the Q&A session. So, yeah, I'm done. I just wanted to say that it was right what the colleagues from the Association of the Relatives of Political Prisoners of Kremlin have said. We have to intensify the input of the civil sector, or then to transfer this law to the security and defense forces. But why do we need the competence and half competence? Thank you, Danylo. And I would like to give the people on the floor an opportunity. I can see Volodymyr Zemchukov. I can, well, I have a lot of comments, but I would like to mention 3 key comments. First of all, Mr. Ihor might have probably probably unwillingly lied to you, because the way it's put together in the legislation, it's not like that. It's about those who ended up in captivity as a result of a Russian aggression. Well, that law was developed back in 2019, and it was applicable for the people who ended up in captivity as a result of defense of Ukraine. It's not like they were sitting at home and the Russians came and imprisoned them. It was about the people who were doing something in occupation, those who ended up in occupation but were not staying at home, those who could leave, those who could hide, but Still, they were defending the territorial integrity of Ukraine, fulfilling their professional duties as law enforcement, as journalists, as policemen, just like patriots. But the fact that they were active before the occupation, we know that occupiers, they had the list of all of the patriots, and they came for them only because they were patriotic before 2022. Well, it's not a motivation for our committee. That person was affected. We don't refuse them, but they are subject to the aid according to Geneva Convention, to subject to another law. They should get compensation from the reparations that are supposed to be paid by the occupiers. And our commission was established specifically for those who were not afraid to do something in occupation. Also, our commission is structured as a jury. Didn't you think, dear lawyers, why there are no questions to the jury? Why didn't you do it in this way, not the other way around? Why don't you explain it to them? Why nobody is asking those questions from the jury? Right. The commission was made based on that principles of the jury because we were understanding that all of the evidences are in occupied territories. Our investigators cannot go there. Our law enforcement cannot go there. We cannot investigate the crime spot. We cannot ask the witnesses, but in order to support somebody, the commission was established and it's working based on the principle of the jury. Yeah, but in your case, Mr. Volodymyr, that's a little bit a different principle. We see that the people who wanted to get involved, those who wanted to share it with the commission, they don't need, yeah, I apologize, but we have law enforcement for that. We have Security Service of Ukraine. I can list you all of the law enforcement agencies who deal with that. Those people are supposed to come to law enforcement. The fact that they have the entry in the pre-court investigation registry, you know, is the pre-court thing. Only the court resolution is a legal resolution. And what we had to consider, well, yes, you know, no one is asking the jury. They're making their resolution, and that's it. So, for your understanding, our committee retains the right. A citizen can prove their right in a year, 5, 10 years. The children can prove it and get the compensation. Even if a person died because of old age, they still can prove it. That's why their right is still there. Thank you. Thank you for clarification. Let me pass the floor. Can you please introduce yourself? Good afternoon. Sezonova Maria, a representative of a Free Civilians organization, a daughter of a volunteer and a priest, a civilian sentenced to 22 years, a civilian who, just like Mr. Volodymyr was saying, was not just sitting on his butt, so to say. First, he was evacuated from Berdyansk to Mariupol, then from Mariupol to Berdyansk, then to Zaporizhzhia, so sentenced to 22 years. Thanks God, the commission recognized him. Then, from after the first application, yes. Then my husband, we've submitted to the an application to the commission. It was the second captivity for my father and the first one for my husband. Back then, they were bringing humanitarian aid to Berdyansk. I'm sorry, I'm a little bit agitated. So we were using the ambulance to transport the medicines. I was dealing with the list of people who were in need of this aid. We were bringing Pampers, the diapers. We were bringing everything for the old people, everything they need, because honestly, the elderly back then, when they were receiving humanitarian aid, they were saying we're not going to accept it if it's Russian, and we were saying like people eat it. We brought it from Zaporizhia, and I was personally putting together the lists. My husband was evacuating the people with my father. They were able to evacuate about 600, maybe 700 families, not persons, but families, evacuated them from Mariupol to Berdyansk, then from Berdyansk to Zaporizhia, and my husband somehow was refused. Again, I don't understand. I want to thank the organization, the political prisoners of Kremlin, also the way of the free. I'm sorry, I forgot the name. So we're taking it apart. We're analyzing it item by item. We've submitted an application to National Investigative Bureau, and I'm just having the question: how come there are two similar stories? It's just that my father didn't want to get evacuated because there were people from his church. He wanted to continue helping them, but again, the result is like he's currently in prison. But we left. We had 3 children under our guardianship. We were understanding that's the second captivity, and hence the question: why two similar stories? The incidents are very similar for both my father and my husband, but still a person who was left without his teeth. He spent 1 month in captivity, probably not enough, but now at 40 years he doesn't have any more teeth. Can you ask a question? Well, we don't make people ask questions just if a person wants to share. So there are similar stories, but still, thank you for sharing. I can see more hands risen. Yeah, let's just make it brief. Thank you for this important panel. There's a lot of questions to the Commission, to the representatives of the authorities. Even me, when Serhiy Tsihipa was taken from he was released from captivity, there were calls from security service of Ukraine to me, and I was providing coordinates. So basically we were all helping, and when now during meetings of the working groups I approach a representative of security service of Ukraine and ask them, how come he still stays in captivity? Why don't you help to get him released? And they're asking me, what do you want? Do you want disbursements? I'm telling, like, I want my husband. Bring back my husband. I need the disbursements now because I'm begging now. I'm hiring lawyers. I'm asking for money. Give me here, give me there. We need those funds now. That's why it's a question to the Commission. What do we need and in which way? And the representatives of civil organizations, they know more about civilian prisoners more than the representatives of the government. And when the representatives of such organizations come in sufficient numbers, they are supposed to influence the resolutions of the commissions. Thank you. Unfortunately, your questions remain rhetoric. We don't have representatives of the Ministry of Development. Let's take the last question from the floor. Good afternoon, Olena Kovaeva, representative of the legal shelter OSPL. Thank you. We work a lot with those who were released from captivity, illegally detained, and quite frequently we come across such issues. But I will have a small comment about the situation from the latest exchanges. It was about the refusal of the committee in cases when a person were sentenced by Russian Federation and were serving those sentences, and based on what they say, the Commission presumed that probably that person the person would defame themselves. I don't know why they would do that somewhere in Karelia, in Vorkuta, or elsewhere in Russia. Still, those people are being deprived of all of their documents, but still they come with they make it out of Russia with some documents about their release. So still the situation unfortunately exists, and I would like to hear a comment from the Commission. How come it happens so? And the people, they have this question like, should I provide a certificate from Security Service of Ukraine that I was cooperating with them? Again, on one hand, we shouldn't recognize the documents of issued by Russian Federation as faithful. You know, it's a disputable question, but if there is a sentence describing espionage and stuff like that, probably there should be some presumption that probably things were like that. And the last comment, well, it's not of a comment. I'm the head of the Liberta organization. We were coming across all of those problems, you know, and I want to say that it's not just said it's a crime when a representative of the commission of the state authority don't know legislation. That's a crime. You didn't know the name of the law. Please open it in our presence and read it. How can you say anything like that? There are 3 reasons when the commission works and when the disbursements are being made. And it's about resistance, it's about captivity, and it's also about just the citizens of Ukraine. How can you come here without the knowledge of the law? Please read the name of the law. Let's hear out to the comment. This is what the ministry has written. Let me finish. Yeah, let's finish with the comment. It's important not to read the comments, but to read the laws. Now that you work with the commission, I can see there's a lot of people who want to be outspoken. Well, based on what we see, the problem is real serious. I spent 11 months in captivity. I'm deputy head of Energodar, and now I'm doubting if I was the first deputy, was I fulfilling some obligations on defending the state? Well, you didn't get your disbursements, for what I understand. Well, let me give you another example. It's not about that. More than 1,000 people were sitting in the basements in our city. The majority are the atomic engineers, the first periods of detention and torturing. They were aiming at persuading the people, the atomic engineers, to work with Russia. Were they fulfilling the function of defending the state, working with Energoatom, a state company, a state corporation, whereas they were operating the equipment on the nuclear power plant, waiting for the nuclear power plant to get back under Ukrainian control? And I'm confident that kindergarten teacher, 57 years old, after she was checked her telephone, she was accused of funding a terroristic organization and sentenced to 18 years. Yes, she was fulfilling a state function because she was detained not only because of her attempt, but because of the policy of the aggressor state to intimidate everyone. So my suggestion is to change. Well, I'm really agitated. I can see that the sentiment of the commission somehow not friendly, but we should break up this discussion probably in different parts, probably to help all of the civilian prisoners kept in detention, probably to look for the mechanisms, how to help with advocacy, how to support them financially so that they could get some packages from outside so that their families could make it. It's a story of the state support. We do it within companies, within municipalities, and I understand that's kind of a specific story because our city is still like grouped together, and another part is documentation of fact of deprivation of freedom as a result of armed aggression. How can we say whether it was a policeman or a teacher? Like no one else, I know how the policemen were acting from the very first day. I was known every single policeman. Today, we know the behavior of every single prisoner of war, save for the cases where we cannot find the traces of the people, but where there were at least two persons, we know who was behaving decently, who was behaving worthily, who was tortured. And isn't it time to get municipal military administrations involved? Every community has a military administration, and with no exception, they cooperate with the Security Service of Ukraine and military intelligence. That's really a right question. A lot of work of military administrations is the monitoring, so we should get the communities involved in work of such commissions. The communities, the local departments of the State Security Service of Ukraine, probably it will facilitate the work if the documents pass through the hands of the military administrations, or at least regional organizations, at least in frontline regions like Zaporizhia, Kharkiv, Kherson region. Those who were mostly affected in Donetsk, Luhansk region, those who experienced occupation, but definitely we need to change a tone in conversation and to proceed to cooperation rather than opposition. Like these were fulfilling the functions, and these were not for third year or second year. We were trying to prove that the mayor of Dnipro-Rudny, who was tortured to death in captivity, was fulfilling the function of the state of a public servant. And the state says, no, he was just a civilian. There is a law that allows compensating the loss of life for a person who was fulfilling a function of a public servant. And the mayor of a city who was standing in front of the tanks, who was trying to protect his city, who was trying to not let tanks come into his city, who was ensuring all of the operations in the city. It turns out he was not a public servant enough. You know, it's such a profound and vulnerable topic, so sensitive and painful. Let's try to summarize it. Look, am I understanding it right? The operation of the Committee on Establishment of the Fact of Deprivation of Personal Freedom. Is that the name of the commission? The speakers are not using the microphones. Well, yeah, it's the correct name, but let's see how it goes. Let's try to summarize it. I'm currently addressing the activists, the civil organizations. We see that the discussion needs to be transferred into a format of a legislators' discussion because it's a matter of profound understanding of by the Commission of the essence of the work they're doing. Dear friends, seems like we've touched upon such a sensitive topic for a lot of people, and this topic needs to be studied. And new approaches developed. And first of all, I would like to thank all of you for this intense discussion. And Mr. Ihor, just in brief, something to summarize it, I want to thank everybody for active participation. I understand that it's the people who care who gathered here, no matter what is their position, but I would like to emphasize back on the results that was what happened. We have two recommendations. One of them is highlighted, one was not. The first recommendation is like we strongly recommend the Ministry for the Development of the territories and communities to implement the regular training for the members of the Commission on what the law is, what is really written there, how to use it, and B, how to work with an evidence base. The members of the Commission don't know how to work with it, but they need to know it. What is evidences, where to get them, how to work with them. And third is the political motivation. It's not in the actions of a person affected. You don't have to evaluate what a person affected did or failed to do. If what we've heard today will transform into a government policy, there will be a small number of people left to live here. We can put a fence and there will be only 100 of heroes left in this country, a country of heroes. That's terrible. Political motive is what the occupier does. Like Kostiantyn said, when they initiate proceedings or they do not initiate any proceedings, not because a person committed some real crime, but because they came to intimidate, to instill their order. And that's the political motive for people who were involved in political activism, as well as for a farmer who was just growing their hands and harvesting eggs. So what I just want to highlight in terms of this discussion, that we have a very, very big request to the ministry. Let's implement this training. We know we can, for sure, our organization is ready to administer the first training for the Commission members. The proposition is such that we can implement it within 2 to 3 months. I think the Commission will consider it and to come up with the conclusions how to make it systemic. Also, for this training, we can pick up the best experts. I'm not ready. Well, I want to thank Ivan Ignatovich, who said that we don't need to work as opponents. We need to unite around the problems. We don't work with them to pick somebody or to poke somebody and to say, like, you're not right. We're here to solve the problems, and we are ready to get involved as a part of the solution. Again, what we've mentioned, but we should highlight it again. It's about the change of structure of this commission, and it's not about the mistrust with the people who work with this commission. I know that a normal and adequate person cannot carry this burden for 5 years, continue making the right decisions. We're all people. We have limited resources, and decision making is quite a complicated process. This is what people learn to do, and we have an assumption that for some cases that are being considered by commission, were being considered by commission for a number of years, so they're all frozen. They're not disclosed. If there is a change in the structure of the commission, that will be a fresh view, people with the new databases of information. Probably they may read the law in a different way, because the civilians are indeed covered by that law, those who ended up in illegal captivity because of the clandestine motives of occupiers. And again, it's the discretion of the committee what to deem a clandestine motive of occupier. But again, if the commission changes their approaches, we would come up with less refusals, and the procedure for the contest selection for the commission is developed by us, and we suggest it's being publicly discuss so that all of the organizations willing can join in. So that's what I would like to suggest. Those issues will solve the problems with construing the law. Well, I would like to thank everybody. Thank you for this discussion. That's really important. We would like to thank you for the work that you've done. Definitely, I would like to thank those who defended and continue defending our homeland, and thanks to whom we have this opportunity to gather here to discuss very important and sometimes very difficult and complex things. But still, we have to continue and work on what keeps us united, to something that makes us stand on the same side. So thank you, thank the armed forces of Ukraine, and glory to Ukraine, glory to the heroes.